When a reporter files a story, the text gets formatted and is quickly committed to the rolling cylinders of a high-speed industrial printing press. But the life cycle of that reporting rarely ends on paper. Within hours, the exact same text is ported over to the publisher's main website, appearing across desktop browsers and mobile feeds. From there, the text migrates deeper into the publisher's digital infrastructure. It is indexed, tagged, and permanently stored in searchable digital archives and automated databases. Finally, the article reaches the edges of the open web, where it is routinely scraped, parsed, and syndicated by third-party search engines and massive news aggregators. At every single stage of this distribution pipeline, a distinct layer of intellectual property law is activated. The right to print is not the right to digitize, and the right to digitize is not the right to syndicate. Distributing a single piece of journalism creates a complex web of legal ownership. To monetize that content safely, publishers must deliberately navigate this web, acquiring the precise rights required for each specific stage of digital distribution. The entire press sector rests on a single relationship: the creator who writes the article and the distributor who finances and publishes it. Inside many newsrooms, management operates under a dangerous assumption. They believe that paying a journalist a monthly salary automatically transfers all intellectual property rights to the publication. From a standard business perspective, this logic feels sound. If an employer buys a worker's time and provides their equipment, the employer expects to own the output. Belgian copyright law actively rejects this intuition. The code operates on a strict anti-automaticity principle. This principle dictates that an employment contract on its own does not strip a journalist of the copyright over their original works. The journalist remains the author. This legal reality applies equally to the independent freelancer submitting a single column and the full-time, salaried staff reporter sitting at a desk in the newsroom. Relying solely on a payroll relationship leaves a publisher exposed. Without a specifically drafted copyright agreement, the newspaper holds no legal defense to authorize the secondary digital reuse of its own content. The baseline of the law is absolute. Journalists are the original authors of their articles, columns, and reportage holds the authorship. The media outlet only ever acquires the specific rights that the author explicitly transfers to them. The mechanism for this transfer is rigid. Against the author, the assignment of rights can only be proven by a formal written document. Oral agreements carry zero legal weight. When a dispute arises, courts apply a standard of strict interpretation to this document. The contract is always read in the author's favor. The consequence of this standard is severe. Any specific mode of exploitation that is not explicitly written down on the page remains the sole property of the journalist. Publishers frequently attempt to bypass this with a generic clause stating all rights assigned. Under strict interpretation, this broad language is legally void. It transfers almost nothing. To safely publish, digitize, and archive the news, publishers must abandon vague assumptions. They must build a highly specific, legally compliant contractual architecture. Constructing a valid assignment contract requires breaking intended uses down into discrete, legally binding variables. The first requirement is listing the exact modes of exploitation, like reproduction or adaptation. Second, defining the scope, clearing the text for print, website, or social networks. Third, setting a chronological limit. Finally, the transfer must be tied to proportionate remuneration, reflecting the right's value. The law places mandatory limits on how far these variables can stretch. A publisher cannot assign unknown future modes of exploitation. A clause claiming rights to technologies that do not yet exist is void. The assignment of future works is also restricted. A publisher cannot claim ownership over a journalist's future output indefinitely. It is only valid for a limited, specified time. A contract that respects these granular limits acts as an operational blueprint, organizing exactly how content can be safely and legally exploited. This granularity becomes critical when addressing secondary uses in the press industry. A text written for a morning print edition constitutes the primary publication. Archiving that text online, incorporating it into a paywall database, or selling it to an aggregator are all secondary reuses. The fact that an article has been published once does not mean the journalist forfeits their rights to these distinct subsequent channels. Under the law, each of these secondary uses requires its own specific authorization from the author, accompanied by an adapted remuneration framework. Managing these permissions individually for every article is inefficient, so these secondary frameworks are frequently negotiated through sector-specific collective agreements. This friction between the initial print run and the digital archive is exactly why the press sector pioneered the formal distinction between paying for journalistic labor and paying for the assignment of rights. Failing to build a separate framework for secondary uses creates immediate liability. It leaves the publisher's digital archives legally vulnerable and the creators entirely uncompensated for the ongoing value of their work. Internally, publishers must negotiate with their journalists. Externally, the entire media sector faces a systemic threat: massive digital platforms and aggregators capturing the financial value of journalistic content online. To address this imbalance, the 2019 European Directive established a new regulatory tool, a related right specifically designed for press publishers. This right grants publishers the legal authority to demand and negotiate remuneration when tech platforms reproduce and distribute their publications. Crucially, this new right superimposes onto the journalist's existing copyright without erasing it. Because the underlying copyright remains intact, authors are legally entitled to receive an appropriate share of the revenues the publisher extracts from those platforms. Reading or drafting a modern press contract requires viewing every agreement through this specific architecture: the journalist's copyright, the publisher's related right, and the author's share of platform revenue. The modern press sector operates on a constant tension, maximizing the digital exploitation of content without unlawfully dispossessing the creators who write it. Surviving this tension means abandoning the fallacy of automatic assignment. A monthly salary is not a copyright transfer. Protection requires an explicitly detailed written contract. A legally sound contract actively distinguishes between the journalist's baseline rights, the secondary uses, and the publisher's related rights, rather than dangerously piling them into a single, vague clause. Building this robust legal architecture does two things at once. It protects the financial value of the journalism against outside tech platforms, while formally respecting the author inside the newsroom. This video provides general legal information regarding the Belgian copyright framework. It does not constitute personalized legal advice.